As the final session for today, session 2 will be conducted under the topic of measures such as area-based management tools, including marine protected area. His Excellency Tembele F.S. Joini, Judge of the International Tribunal for the Law of the Sea, will moderate this session. So Judge Joini, please, the floor is yours.
Thank you very much for giving me the stage. Let me start by thanking the organizers of this conference, starting from the Minister of Foreign Affairs, of course, the International Tribunal for the Law of the Sea, and the President is here, the Korean Society of International Law. I must say that when I got the invitation, I was pleasantly surprised, but I felt humbled by the honor and privilege of being invited to come here and be one of the moderators on this important conference. Then I've got with me 4 colleagues and friends, and I've got 2 speakers and 2 discussants. Then I'm going to introduce the first speaker, and after the introduction, I'm going to send her to the podium. The first speaker is Ms. Renée SAUVÉ. She's the Senior Advisor and Consultant on International Oceans Policy and recently retired from the Canadian Department of Fisheries and Oceans. Upon graduating with a degree in Natural Resources, Ms. SAUVÉ spent the early part of her career as fisheries biologist in the Arctic and on the west coast of Canada. Ms. SAUVÉ began to specialize in international oceans policy in the 1990s with both the Department of Fisheries and Oceans and Global Affairs Canada. In this capacity, she headed a number of Canadian delegations and chaired international ocean-related committees and negotiations in a number of international organizations, including the UN, Conventional on Biological Diversity, that is CBD, Food and Agriculture Organization, and the Arctic Council. She chaired the negotiations of Part 3 on the area-based management tools, including marine protected areas of the Agreement on Biodiversity Beyond National Jurisdiction, that is BBNJ, which was successfully concluded in March 2023. Renée, take the podium.
Your Excellencies, colleagues, thank you to the organizers for bringing us together, and specifically on this topic. It's very timely, and I find that opportunities for us to stop and reflect are few and far between. So these kind of gatherings with relevant expertise is very useful. As noted, I have been involved with the BBNJ process for a long time, back to the early 2000s. And I was very motivated to try and get the agreement across the line because I made a commitment that I would not retire until we finished the agreement. So I promptly did retire after the spring. For those who are maybe a little less familiar with the BBNJ, just a little context quickly. So the formal negotiations started in 2018, And the early days, the expectations that it would go fairly quickly, and some people pointed to the fish stocks agreement, the other implementing agreement, and it took around 5 years. But I think it was a bit erroneous because people forget that the fish stocks agreement focused on a single activity and a subset of fish species. And in terms of being directly implicated, it was really a smaller or limited number of states. So BBNJ is very much a different beast. The breadth, holistic nature, I think, will in fact be its novel element, but also I think will continue to be a challenge from a policy, ecological, and political perspective. So BBNJ, as I said, is notable for a novel and ambitious objective to really reconcile the interest and activities for the global oceans. This is no small task, of course, and means there are fundamental and persistent challenges. Trying to implement and manage place-based approaches in a three-dimensional ocean environment is that maritime boundaries are often not resolved. Adjacent jurisdictions are legally discrete, but ecologically intertwined. So trying to have this broad overarching mandate that BBNJ has, but it lands in an arena with well-established global and regional bodies and processes. So really, the big question is BBNJ, the agreement we have, and the mother agreement, UNCLOS, really up to the challenge? Just to give you a bit of an overview quickly of the negotiations, in considering the various components of the draft agreement, the initial assumption was that the MDR obviously would be a very challenging part, and I do not envy Ambassador Felsen at all for having to try and steer that. But it was also assumed that the ABMT section would be extremely hard negotiation. Early negotiations were a bit constrained by an early mandate from the UN Resolution 72-249, and it was referenced earlier this morning, the together and as a whole. So the two main drivers that we see in the agreement, the conservation driver and the sustainable use side, were really tied together. And it was, I think, meant largely to not allow one to get ahead of the other. And this was, I was a negotiator at the time, and I think it was a bit of a constraint to those early negotiations. But as talks progressed, the ability for Part 3 to make progress became more evident for a couple of main reasons. Unlike MGR, there was no obvious or upfront funding demand, and applying place-based management was a concept that a lot of countries were fairly familiar with. It wasn't something completely new. So in the end, after ensuring sovereignty and jurisdictional concerns were addressed in the text, getting agreement on the bulk of Part 3 was relatively, I like to say, bloodless or relatively painless. Sorry, I'm a little behind there. So the objective of Part 3 was to lay out a process for establishing and managing ABMTs. And as summarized here, you can see we tried to do it and organize it in a fairly logical flow. From instigating or developing a proposal, to elaborating it, to reaching out and consulting on the proposal, outlining types of decisions that the BBNJ COP can make for establishing an ABMT, to how decisions can be taken by the COP, including the aspect of voting, consideration of a fast-track option under emergency situations, and the actual implementing of the ABMT, and finally, requirements for monitoring, review, revision, and reporting. I think it might be in human nature to focus a bit on the negative. I think it was a study by Harvard Business School that looked at social media. And even if initial posts are positive, in fact, it is the negative comments that get the most quickly picked up and widespread. So I think while it is important for us to consider what lies ahead of us and what may need fixing or refining, but I think it's important not to lose sight of what was accomplished in the agreement and the ABMT section and some of its strengths. It is legally binding, shall establish. I see strong language here. Parties shall ensure activities are consistent with decisions. Recommendations are made to other bodies, and parties shall promote. There is a high degree of engagement and transparency. Information sharing is throughout the different provisions about broadly share, making publicly available information throughout the process. So I think these are very strong elements that we not forget we are able to get in the text. Nevertheless, in making the agreement real, we need to give careful consideration on how the governance structures and processes are designed. This will determine ultimately the success or failure of the agreement. As we go forward, I would note some important considerations. For example, the scientific and technical body. Will it be empowered to reach out and tap into necessary information? And it will really need a wide range of information. It's unlikely that one single body will have all the appropriate expertise for an agreement such as BBNJ. Will it be empowered to do that, or will that all have to go through discrete COP decisions? I think you see how that could probably slow things down somewhat. Will the STB include legal or jurisdictional experts? Or will that expertise come through other parts of the agreement, the compliance body or the dispute settlement mechanism? Will the scientific and technical body elaborate a practical understanding of precaution? When we look at how states have dealt with precaution and making it real in their jurisdictions, they have often found it necessary to elaborate on the definition in terms of how to implement it. So this may be something that we need to consider when we're looking at trying to implement the BBNJ. There are a collection of challenges related to coordination and cooperation, including roles and responsibilities of IFBs. Well, the agreement, I think, is quite clear on some aspects of the role of BBNJ. It's a lead on coordination, formalizing biodiversity objectives, the lead on reviewing, revising, making recommendation on ABMT proposals. But it is not yet clear how to incorporate or endorse IFB information, data, or the efforts of these other bodies. And probably more fundamentally, what does it practically mean to not undermine? We've heard this in other presentations. And during negotiations, there was, as you can imagine, a good degree of debate on this particular topic. Does it mean to not impinge upon the legal competence of the body, or does it mean more not to impede the effectiveness of the body? And another point that was often made is that it's important that we consider it goes both ways. We can't undermine IFBs and IFBs cannot undermine, of course, the mandate of BBNJ. The role and responsibility of coastal states engendered much deliberations in New York, and there are a number of references that you've probably noted with regard to coastal state interests. Article 22.6, reference to, as we say, high seas pockets in 21.4, for example. These references are in essence consistent with UNCLOS, and I think that might imply not a little practical difference between coastal and non-coastal states. So the question, I think, an important question for us to consider as we're looking at implementation, would more differentiation between the two, allowing for responsible roles and not just focusing on the rights of coastal states, would this facilitate implementation? I think we know that in some cases, the best knowledge and capacity exist with these coastal states. Leadership could be demonstrated by them helping to shape regional objectives with the information they have, and they could step up to provide a leading role, providing monitoring and reporting functions. But during negotiations, there were those who thought that coastal states were given too much latitude. As we heard a reference already to the fact that there was the development of an opt-out option and the objection procedure. It is evident that in some multilateral fora that consensus-based decision-making has impeded some conservation objectives. Hence the proposal for an objection process opt-out and voting during the discussions of COP decision-making. So, in an effort to avoid this and to provide some deference to coastal state rights, we did develop the opt-out option. Clearly, this was one of the hardest provisions during our discussions. An agreement was only reached after an elaborated list of constraints. So the need to provide very clear rationale, a sunset aspect, the need to provide alternative measures to try and achieve the objectives, regular review, and all these decisions being made public. I think in the end, there was really a pragmatic acceptance that having the option, whether used or not, would actually increase ratification. And I think, as we've heard from previous speakers, having more universality, especially for this kind of agreement, is especially important for its effectiveness. Deliberations around decision-making also led to discussions around obligations. In other words, how binding are decisions and on who? For example, if a state is party to UNCLOS but not BBNJ, how implicated is that state? Do the UNCLOS obligation to protect and preserve the environment and what we see in Part 12 of the Convention, do those represent generally accepted international rules and standards? And is BBNJ consistent and therefore applicable? Are BBNJ signatories bound by ABMT measures because signing represents consent? I think most would agree that that's probably not the case. Having said that, a signatory must not act against the object and purpose of a given treaty. So being a signatory to some degree represents a commitment. Another scenario that was considered was a state that is party to BBNJ, but not a relevant regional organization. It raised questions such as if and how to recognize existing ABMTs and existing work. I think most delegates in the room agreed on the practical need to take advantage of any significant technical work and progress that had been made. But there was a strong reluctance by a number of states to simply accept the results of a regional process by a subset of states that they were not part of. So I think that's a reasonable concern. In this scenario, does non-recognition under UNCLOS and BBNJ affect the legal status of the existing ABMT? And when we look at moving forward, can things be expedited by developing what I call a designation light process for incorporating these regional efforts into the global instrument? Something on our to-do list going forward. Related to obligations is the issue of compliance, and we've heard a little bit about that today. What does the agreement say about this? Well, I think it's pretty clear on reading the agreement that there was the decision to take a non-punitive approach to enforcement and really focus on compliance as we see capacity building in Part 5, ensuring transparency in Part 6, and providing implementation advice in Part 8. However, we do see a reflection of the fish stocks agreement model, where parties must respect conservation and management measures with regard to the agreement, regardless if they are part of the RFMO or not. And that cooperation element is also in Article 25 of BBNJ. As we look forward, we know that remote sensing is becoming increasingly accurate, increasingly available. One considers a situation, would BBNJ parties in the future want to maybe opt for using Port State Measures Agreement in the face of flagrant non-compliance and with ABMT measures? I think from the discussions in New York, I think it's safe to say that currently there is little to no appetite for targeted or active enforcement action. Important difference with the fish stocks agreement that there is no obvious current economic levers or interest at stake, such as access to a fishery. Instead, BBNJ relies heavily on flag state responsibility, duty to cooperate, and decisions and reviews are made public, all as incentives for compliance. Considering implementation in general, I would like to touch on just briefly Article 24 related to emergency measures. Given all the governance complexities, scientific and political constraints, some of these still to be revealed, I think people are worried about the timely implementation, and that will be a real challenge for BBNJ and ABMTs. Possibly that may have been an impetus for the later addition of this emergency measures article, but I think it was understood that during discussions that this much more work will have to happen with respect to this article as we go forward. One question that was raised during our deliberations: does climate change in itself represent an emergency, and then make this article relevant? I think those discussions still have to happen, but I can indicate that the initial discussions in New York indicated that that was not the general understanding for the relevance of this article. initial discussions were really thinking about more targeted scenarios. The challenge, however, when we consider this article will be what is the gap that BBNJ would need to fill? And how do you expedite action and yet still have credible information and adequate consultation? And we heard from delegates that those were two very key things, especially with respect to Part 3 of the agreement. So, looking at all these components, and this is just with respect to Part 3, there is a very long to-do list for the COPs. I think, obviously, initial efforts will have to be focused on sorting out these governance structures and mechanisms, and it will need solid policy and legal analysis and advice. And I think that's where a number of people in the room will come in with their national delegations. Applying this holistic approach on ecosystems and not single activities or single pressures, such as pollution, one leads one to ask the question, is the ultimate framework, is UNCLOS really up to the task of supporting this kind of implementation of this somewhat different agreement that we have before us? Instruments, concepts, terms, as we know, evolve over time, sometimes through dispute settlements and advisory opinions. So we should ask ourselves, is more effort needed now maybe to elucidate some of these underlying concepts, such as not undermined, due regard, duty to cooperate, or how to apply precaution in a BBNJ context? Does the next generation of UNCLOS require maybe some new interpretations or expanded interpretations on some of these concepts to support the application of an integrated ecosystem-based management to address cumulative impact? And I'll leave it at that.
Thank you very much, Renée. Well done, well done, well done. And thank you very much for your comprehensive and informative presentation that gave us both the context and the significance of the BBNJ.